Very good afternoon to everybody. We are running a little bit behind time, and I will use this panel to ensure that we get back to the time slots that are originally allotted, except to try and ensure that in that process, we do not really economize on the content of the panel. As was mentioned earlier, we have two very distinguished panelists. We are missing Mr. Pramod Kumar, who is a member of the Income Tax Appellate Tribunal and who originally was to be here, who today hopefully is being elevated as a Vice President of the Income Tax Appellate Tribunal, is awaiting his orders and therefore could not be here because that induction has to happen today. But as I was sitting down, talking to Justice Pagone, talking to ma'am, we just started discussing a variety of subjects. And one of the very interesting things which came up as I was talking to Justice Pagone was an Australian judgment with which I was concerned personally as an advisor to one of the software companies which he has authored, and how the law is evolving in Australia. And if we have seen the countries and how countries are really interpreting the tax laws, after the Indian judiciary, which has now earned a name globally in being at the forefront of interpretation of tax laws, Australia is one of them. So hopefully we'll have in the course of the panel discussions today a very involved discussion on some very serious aspects. Let me begin with a brief introduction and then put the questions to the panelists. When BEPS happened, one of the, and this was the first Taxsutra panel which we are having here in this very same forum, and just a couple of days back, BEPS recommendations had just been announced. It was probably the first forum where they were being discussed anywhere. And I remember one of the issues which came up was consistency in interpretation of tax laws. And the expectation was that post-BEPS, tax laws will be interpreted in a consistent manner. Sure enough, a matter came up before the Income Tax Appellate Tribunal, and one of the sides presented their thoughts on how the law ought to be interpreted, having regard to the BEPS recommendation. And the Income Tax Appellate Tribunal went on to hold that BEPS is a policy framework. As a policy framework, it is relevant for the legislators to take that into account and form their laws appropriately. But it is not relevant to the judiciary at all, and therefore the submissions with regard to BEPS were disregarded. A couple of years have gone down the line, and the question which is now coming up is that, is BEPS relevant only and only when it is legislated? For example, there are many aspects of BEPS which are beyond legislation. For example, we are looking at issues on transfer pricing, which are really more policy frameworks as opposed to there being any legislation. And you can broadly agree to that policy framework. And I just wanted to ask, first of all, beginning with Justice Pagone, that would you believe, sir, that BEPS is relevant only for the legislators to decide on the policy framework, or as the judges interpret the law, having that background of what is being intended, how the law is evolving globally, is something which they are going to factor and take into account?
Yes, thank you for that question. It's a difficult question really to answer at a profound level. At a simple level, it's easy enough to answer. But BEPS, of course, is relevant as a policy measure for the legislatures, and the judges, as a practical matter, have regards to BEPS only to the extent that it informs the interpretation of domestic law. So, practically speaking, BEPS has no direct application because under Australian law, and I assume under Indian law, the question is one of interpreting domestic legislation. And added to that is the complexity that our judges are appointed from a broad pool and are not appointed to a specialist court, a specialist tax court. So that you might have, as you did have with me, who had practiced extensively in tax before I was appointed as a judge, but the great bulk of my colleagues were not conversant with tax law or tax jurisprudence and tax litigation. And that meant that when they looked at words in the way that a bewildering rabbit might look at the headlights of a motor car and not make the same sense of the legislation as we might make. Now, there's a long and strong tradition of that kind of approach, and I believe it's largely the position in India as well. So that means that as a matter of practical reality, judges tend not to either understand or have much regards to the BEPS broad policy, although theoretically it can be taken into account as a matter of interpretation, and in my view should be, because the legislation, the domestic legislation, is intended to give effect to and therefore to reflect these broad considerations.
No, thank you for that answer. Ma'am, before I flip over that question to you, again, just to give a preamble, clearly if there is a domestic law and the domestic law gives a particular sense of interpretation, that's all that a judge would do. But today, most times, when one is looking at purposive interpretation, when the law is capable of multiple interpretations, when one is looking at maybe perversity of drafting, would one not want to go to the BEPS policy framework? And again, as I mentioned earlier on, we have a number of things which are not capable of being legislated, but which is purely a direction. Would, in the interpretation of law, that direction be taken into account by the judiciary?
At the outset, and before I address the questions itself, let me say that it's a pleasure to be here this morning with all of you, and I would like to thank the organizers for this invitation. BEPS is, as I see it, a wonderful policy, a wonderful set of guidelines that has been necessitated on account of the changing scenario in the tax world today. It's not that one didn't have guidelines earlier. Guidelines were always existent, and many of them provided by this very organization that has formulated the BEPS policy. But the necessity for it is on account, in fact, the Deputy Director of the OECD in her presentation used the word aggressive. I would say aggressive and ingenuous methods that are adopted by tax practitioners as well as corporates today to design strategies, also premised on the availability of online resources and e-commerce that have changed the tax scenario in totality. Now, you will have noticed that I used the word authorities in the earlier part of what I said. And the reason for the use of that term is conscious. As part of the judiciary, the Indian tax enactment brings to our table those matters that involve not just a question of law, but a substantial question of law. You're aware of Section 260A, which says that what the tax courts decide are those substantial questions of law that arise from the litigation before them. That, I believe, will have a bearing when we see the impact or the relevance of BEPS as far as the judiciary is concerned. Why do I say this? It is essentially the tax authority or the revenue authority who has before him or her all the materials to formulate an assessment, a tax assessment. It is at this stage that they have all the necessary reports, your transfer pricing reports, your country-by-country reporting standards that have now been prescribed. All this is mandated to be given to that authority by the entity in question. And it is on an analysis of these materials that an assessment is framed. Therefore, when it goes through the tiers of appellate hierarchy to come before the High Court, we expect that all these factual questions would have been looked into, would have been analyzed and determined when the matter is actually before us. So now coming to the scope of judicial involvement in such a matter, it's not much. Offhand, I can think of two situations where the judiciary could, yes, intervene. One would be a situation where such very, very relevant documents have not, despite the best efforts and due diligence exercised by the entity, been permitted to be placed before the lower authorities. If the SSC is in a position to establish that despite our best efforts, we were not in a position to place relevant material as prescribed by various standards, both domestic as well as international, that would have a bearing on the decision of that issue, then yes, the judiciary will intervene. And we will say, yes, those documents are liable to be admitted, even at this belated stage, notwithstanding that the documents ought to have been produced either before the authority at the assessment level, the commissioner at the first appellate level, the tribunal at the second appellate level, but still, the discretion is with us to say we will admit it. So that is one situation where there is a role for the judiciary to play. The second situation that I can see offhand is the question of perversity. Perversity of fact is still a substantial question of the law. And therefore, if it can be demonstrated before us that in the application of assessing standards, which take into account domestic as well as international conventions, literature, judgments, etc., there has been a perversity in appreciation of that issue. That again is another instance when the judiciary will look into the question. I believe that will answer both the questions raised.
Absolutely. Just digressing from the topic of BEPS and what we are talking about, and speaking about perversity of law, and being a practitioner of tax that I am, I was quite amused to read an article this morning where a tax authority adjusted refunds against the demands which are due without giving a notice to the SSC as to whether the demands and the refunds could be adjusted. And the court actually went on to hold, and I think it was the Bombay High Court, which went on to hold that the adjustment was incorrect and therefore asked the revenue officer to pay the refund out of his own pocket.
Yes, we have seen that some courts are very proactive in touching on issues where derelictions are pointed out on the part of the assessing authorities.
In many cases we go on saying that judiciary is the last hope for this country, and that's not belied. Moving on from there, ma'am, if I could again, begin with you on a subject of convergence. And I mentioned this in my preamble, that one of the expectations in the context of BEPS was that now that we have a global framework and laws are evolving from that global framework, would there be a consistency in the application across the world? Would the foreign judgments be now even more relevant all across the world? Because the basis is common, that's one. And married with it, I would ask another question, which of course is a subject in itself, that as we look at BEPS, there are certain terms like principal purpose test, and now the emerging theme of significant economic presence, where one may not really find ready-made definitions or parameters. How do you see all of this interpreting, and how do you see the judges dealing with these issues? And do we see more consistency, more divergence in the judgments which come across?
Responding to the first part of your question, I think the volume of Indian precedent that you have, that has emerged from the High Courts as well as the Supreme Court, will show that our courts have always been open to foreign judgments, literature available in the international domain as to how a particular issue is to be viewed or interpreted. And that being the case, I would think that the material that is now being added to this volume of literature can only be a very, very effective guideline that will also certainly be taken into account, subject to the caveat that I mentioned in response to the earlier question, by the courts in deciding questions. There is absolutely no difficulty with that. Now, coming to the second part of your question regarding the specialized form of tax litigation, or the nuances and the niceties of tax litigation that may not be very readily appreciated by everyone in the judiciary, well, that is an issue that one has to contend with. Now, speaking for the jurisdiction that I come from, we have a system where there is a rotation of judges, and the tax bench and all other courts are normally, this of course is subject to the discretion of the Chief Justice, will normally be rotated every 3 months. And other courts across the country have their own methodology. Some of them have specialized courts sitting for longer lengths of time. Some of them rotate them on a fixed basis. But I do agree that specialized subjects may call for specialized handling. And this is a trend in the sense that, now we have the Commercial Courts Act. But having a specialized court would be of no use or no purpose unless you have a specialized person to man the court. Therefore, I may not be able to comment much more on this because we adopt the rosters that are handed over to us. But speaking generally, yes, it is necessary that when a specialized subject is being dealt with by the court, it would be preferable that the judge handling the jurisdiction brings some experience to the table. It is all right if it is a person who has had experience in handling those matters. For instance, all the phrases that the moderator mentioned would be permanent establishment or whatever it may be, would be matters that one has handled personally. And therefore, one would have some experience as to how they are to be viewed, how they are to be interpreted, the jurisprudence available on it, the volume of litigation, the volume of interpretation that is available internationally and domestically. But to a person who has come to the jurisdiction for the first time, yes, it would take some time for them to grapple with it and come to grips.
Thank you. You also mentioned, sir, in your remarks to first question about how you don't necessarily have judges only dealing with tax laws. How do you see that in Australia? How do you see it impacting the judgments which come out? Tax is becoming such a specialized subject. Is there not need for dedicated benches at the courts? And then the earlier question which I raised, which was, how do you see the convergence of laws now that there is a possibly global framework on the basis of which all domestic law has evolved?
Well, let me deal with the latter part later, but I think there's a real problem if you do not have specialised judges dealing with specialised matters. It's interesting, I think, for us all to go back and look at the development of the Commercial Court in London 100 and more years ago, because the spark that caused the establishment of the Commercial Court was a judge having made a decision that was so outside of his zone of comfort and expertise that it was thought to be an embarrassment. Now, the point about that is not that it was an embarrassment. The point is that the public needs to have confidence in the decisions made by the judiciary. And that confidence is something that comes if those who decide cases have about them the knowledge and the wisdom of being able to decide the subject matter with the confidence of the people who come to have their disputes determined. It's a matter of public confidence, it's a matter of the integrity in the system. I think, therefore, it is important that there should be judges who are specialised in the subject matter that they deal with. They shouldn't be the only people deciding matters, and indeed the system in Australia is one that has, on the appellate level, the ability to mix on the appeal court a specialist judge in a field together with one or two or sometimes four others who bring to the decision a broader outside view. And I think that's a good thing, to be able to have non-experts weigh in on the disputes and say, well, I don't care what you people think is the relevant provision, it just can't be like that. But that's where you've got a mix. But at first instance, I think it is important that the system have about it robustness, and that the people whose affairs are being affected, and I don't just mean taxpayers, I mean taxpayers and the regulators, both have confidence that the people who are going to make the final decision about what the outcome and the rights are people that they can look up to as having the kind of expertise and knowledge that they ought to have for that confidence and integrity to be maintained. Turning then to the second part of your question about the convergence, I must say one of the big problems about the role of the judge in the deciding of a case is caused by the influence of those who appear before the courts to argue the cases. Judges inevitably do not have the resources of the parties or the knowledge of the parties. And what that frequently means is that the judge is at the mercy of, they are vulnerable to, the expertise and knowledge of those who are appearing before them. And sometimes the interests of the parties, whether it be the revenue authority or the taxpayers, or both the revenue authority and the taxpayers, the interests of the parties are such that something that should have gone to the court does not go to the court for one reason or another. Now, I can think of a lot of examples where that has been the case, and I won't bore you with all of them, but let me mention, if I may, two matters. One of them involving an Indian case, or at least a case involving Indian litigants. That's the case of Tech Mahindra, where the case was decided in the federal court, not by me but by my colleagues, without knowing, nobody told the court that there was a decision of your court on the very treaty that was in dispute. No one said anything about it. I can assure you that my colleagues were somewhat annoyed when they discovered that there had been a case that might have informed their judgment and had not been brought to the attention of the court. But it didn't happen. One asks the question, well, why didn't it happen? Well, the answer to why it didn't happen is complicated. I don't actually know, but I can guess. One of the reasons is that both parties thought they were better off not referring to it. And that's a bad thing, because the court is at the mercy of, and then you might get unusual and inconsistent and awkward answers. And indeed, after the federal court gave the decision that it did, there was an application for special leave to appeal to our High Court, which is the equivalent of your Supreme Court. And one of the arguments was the decision of the federal court, they said, was inconsistent with the decision of the Supreme Court of India, which nobody had bothered to tell the court about. Now, that situation just shouldn't be allowed to happen. There should be more convergence. And one of the reasons why there is not convergence is because it's sometimes not in the interest of the parties for the matters to be drawn to their attention. That's the first case. But the second case is in its own way rather peculiar. And that's the case that was decided by the full federal court yesterday. That was the matter of Satyam Computer Services Limited.
Incidentally, they both happen to be sister concerns.
Yes. I haven't fully digested what Satyam was all about yet, because I literally woke up at 2 o'clock in the morning with different time zones, and somebody sent me a text message saying, if you haven't spoken yet, you might want to mention this decision. It had only just been handed down earlier on that day. I haven't really had the time to digest it. But I do know that what happened in that case was that there was a question, amongst many others, about whether the effect of the India-Australia Treaty deemed residents where there might not otherwise be residents under the domestic law. There seemed to be 4 or 5 Indian cases on point, and the full federal court just said, well, that's very nice, thank you very much for telling us, but we are not going to follow them. And precisely why they took that view is not clear from the judgment. You can read it in paragraph 21. It won't take you very long, but it won't enlighten you as to the reasons. I will ask my former colleagues offline at some stage as a matter of interest.
That's very interesting, although it is moving away from the subject of BEPS, sir. I'm familiar with the judgment which Your Honour wrote in the case of Tech Mahindra, and I think very serious ramifications for the Indian software industry, because one of the questions there was whether the treaty definition of royalty, which was a much narrower definition compared to the domestic law, which was far wider, would apply having regard to certain specific provisions of the treaty. So I haven't still had a chance to go through the judgment which came yesterday in the case of Satyam, but I'm sure many of us here would be very, very interested. But moving on from there, one of the things I must ask you is how long does it take in Australia for a matter to get resolved at what you call is your High Court? And let me give you the context. In India, you normally have an assessing officer, a decision from him or her would go either to a dispute resolution panel or to a commissioner appeals, from there on to a tax tribunal, High Court and Supreme Court. And the time lag from the officer to the Supreme Court could be anywhere between 15 and 20 years. So we normally say that you create a dispute and your children are there to solve it for you. How long does it take in Australia?
I'm pleased to say that it does not take that long at all. Our cases can be decided much more rapidly. It partly depends upon the complexity of the question, how the matter comes on, and the importance and significance of the issues. It is theoretically possible to have the matters resolved within a matter of months from beginning to the highest court. That doesn't happen often, but it could. Practically speaking, a case from initiating in the federal court to its appeal process and ultimately going on special leave to appeal and decided in the High Court might take about 3 to 4 years, maybe 5. But within that order, it should all be done and dusted.
Excellent. And one other question which I had the pleasure of asking a judges panel last year. Does Australia rely on only written pleadings or oral arguments are permitted?
This is like asking me to opine about one of my favourite topics. We, like you, come from the English legal tradition, and therefore we, like you, have traditionally relied upon oral argument. And that is pretty much still what happens, but the winds are changing, to use the words of the song. And indeed, my constant mantra to everybody in my jurisdiction is now oral arguments are much less important than written arguments, substantially less than written arguments. And that's not because oral arguments don't occur, nor is it because oral arguments don't take a long time. It's a practical reason why the written arguments are fundamentally more important than the oral arguments, and that is that when the judge needs to write the decision, the judge is sitting usually in chambers, quietly at night, can't remember what was said in court, and if any judge could remember that much, they probably are in need of psychiatric assistance, because you just can't keep that kind of knowledge in your head. What they always do is go to the written submissions. And it's the written submissions that will form the basis upon which I would say 95% of all Australian judgments are made. We pick up the written submissions to remind ourselves and to identify what the parties had said about the matter. And it's really the written submissions that form the absolute fundamental basis upon which we then start to write. And I remember being in a meeting of judges where the first of us talked about the importance of the written submissions, and then all 40 began to. It was like sort of singing a choral at King's College, Cambridge. It was all the same tune. Now, there's a lesson there to be learned for practitioners. It's not a matter of looking well-dressed and careful and persuasive presentation. It's writing it out in a way that's effective in writing.
No, interesting. I again recollect talking to a US practitioner saying that if at all you are permitted to make an oral argument in USA, it could be a 15-minute, otherwise you've got to rely on your written pleadings. But I was coming to more BEPS and the fundamental issues, ma'am, and if I could lob the question to you. We have our judiciary system, we have our backlog. We just read how the new Chief Justice is trying to ensure that judges don't take leave on working days and sort of clear the backlog, but that will correct itself in due course of time. But one issue which comes up is that in the context of international matters where there is a dispute, nobody would like to carry forward an uncertainty for a prolonged period of a decade and a half or whatever more it takes. And then you have the competent authority proceedings. And competent authority proceedings, again, there is no mandate that one has to agree. It is not unusual to find competent authorities agreeing to disagree. And therefore, BEPS came up with a proposition about international arbitration that was not a minimum standard. So countries were free to adopt or not adopt it. And India chose not to adopt it. And like USA, India would like to believe that submitting itself to international arbitration is sort of violation of sovereign rights. How would you look at a situation where disputes, so I'll give you a very concrete example, as to characterization for payment for software, whether if it's a customized software, off-the-shelf software, what is royalty, what is not, is a matter which is going on for the last 20 years and will continue to go on until we get some Supreme Court judgment. Until then, there are on-account demands, payments, etc. Now, is arbitration not a way forward, and how would you look at that whole
You have just suggested arbitration as a remedy for reducing delays in disposals. Before I address that question directly, there are many kinds of methods by which pending litigation can be disposed of. What immediately comes to mind is the delays caused by the stakeholders in the system itself. If adjournments were not sought and matters were proceeded with, that would be one method by which delays would be reduced. Second, systemic delays. For instance, when I sat on the tax bench, you have a judgment that you have rendered on any specific issue, say royalty or depreciation or whatever it may be. You believe that it may have an impact as far as other pending matters are concerned. So what do? You ask the registry, can you give me a list of matters involving similar questions so that we could bring it up together and try and see if other matters could be disposed of as well. That would bring down the glut in pendency. Now, the system does not provide for capturing of such data at the level of the registry. So what we did with the active encouragement and the support of the Chief Justice of the Madras High Court at that time was to in fact request 2 persons from the Income Tax Department to come and sit with our registerial members to sort out the matters, all matters. From our part, we amended the filing form. When you file a tax case appeal before the High Court, it has to have a filing form which has to indicate certain particulars that are dealt with in the appeal. So we added a few columns to also indicate what are the issues involved in that appeal so that they can then be transferred to the computers and the computers will be able to do the job of clubbing. So these are things that can be done very easily to address the question of pending litigation. So that's as far as systemic approaches to pendency of litigation is concerned. Now coming to the question of arbitration. Now, as was mentioned, arbitration is one of the methods that are globally accepted for easy resolution of disputes, both commercial as well as otherwise. But bear in mind that it is not a conventional form of dispute resolution. It is an alternate method of dispute resolution. Arbitration, along with mediation and conciliation, are internationally regarded as ADRs, alternate dispute resolution methods. And there is a fundamental difference between ADR methods and traditional methods. The question is, will a country which has as its sovereign right, the right to tax, permit the subjecting of that sovereign right to an alternate dispute resolution system which essentially takes that right out of his hands? That's the question. In fact, the moderator made reference to it by saying that taxation is a sovereign right. That is, and I see the reports in the media about our country's response to the suggestion that mandatory arbitration be adopted as a method of tax resolution as well. That is a decision to be made at the policy level. But let me talk about my experience on this. In my experience of more than 2.5 decades in dealing with taxation, both in my earlier avatar as a practicing advocate as well as now, there have been only 2 instances where tax disputes have subjected themselves to arbitration. One was a matter where, if I may take a few minutes just to outline one was a matter where it was an installation contract involving a public sector undertaking in India for whom we appeared, and a foreign company. And the crystallization of tax itself, the crystallization of the taxable income and the tax itself was done by the tax authorities. The parties had no say about that. The question that rose, that was subject to arbitration, was which portion of that will be paid by which party? And more recently now, you would have seen the Nissan dispute, which is also subject to international arbitration. There are litigations that have been filed before the High Court as well, while sitting in the arbitration jurisdiction for the better part of 1 year. In fact, I had occasion to deal with those Section 9 applications that dealt with the Nissan arbitration as well. There again, the question that arose was not what is the taxable income and what is the tax to be levied. That cannot be subject to the decision of a private arbitrator. As of now, the system does not permit.
No, as of now, of course, the system does not permit. And my question, which of course you've answered, is should India really, having regard to the length of time that it takes to resolve a dispute, really concede to that on a policy matter?
May I just take 30 seconds more? The premise on which the moderator puts this question is that arbitration is a speedy resolution or mediation is a speedy resolution. We have had instances when arbitrations and mediations take as long, if not longer, than conventional litigation. So that by itself may not be an answer. It really depends on the parties to the arbitration and the arbitration panel itself to decide, to put their minds to it and decide whether that dispute is going to be resolved soon or not.
Here the proposition was that when a matter goes for a competent authority resolution, if in 2 years' time the competent authorities cannot come to a resolution, they go to an international court. Your thoughts on the subject?
I also agree that sometimes arbitrations take a lot longer than the so-called traditional judicial processes. We might just ask ourselves, though, why do people want to go to a mediation or arbitration rather than the court processes? Because these decisions are not made at random or theoretically. One reason is speed, sure. But another reason might actually be that they don't like the decision maker. That being able to impose upon let's say, select who the decision maker is going to be will give you a better outcome than relying upon the randomness of the judicial process, which may give you somebody as a deciding judge who might not be your ideal choice. So these are practical considerations about why somebody would go to mediation. But can I just take a slightly different spin on the broader question, if I may? Of course, tax is a sovereign right. I agree completely with that, and that's a given. The difficulty, though, is that it's a sovereign right that's a little bit complicated. It's a sovereign right that has been complicated by international agreements. And in part, the question for the sovereign countries and the application of the sovereign law is to what extent the domestic law is to be interpreted in a way that's consistent with the way in which the same provisions are interpreted and applied in either the other party to an agreement or, more broadly, in an international forum. Now, it seems to me that the sovereign right, having been exercised by adoption of international standards, carries with it some form of acceptance or a sovereign obligation, to use your words, a sovereign obligation to adopt the international norm. And that, I think, should be resolved by an international body in some way and then applied domestically, with the sovereign right always being to depart from the treaty, but to do that not by the judges, but by the legislature.
Good, thank you. I think we are likely to hopelessly run out of time. So one very last point for you. You mentioned about a couple of judgments on anti-abuse which have come from Australia, which you wanted to talk about. So 3 minutes.
Oh, well, I think it would take more than a few minutes to talk about the Australian anti-abuse, but certainly what we have done in Australia is to have adopted a relatively strong anti-abuse provision, starting from a case that I'm sure many of you will have heard of, the case of Spotless, where we took the view that the anti-avoidance rules were applicable. What's interesting about Spotless, if I may say so in a nutshell, is that the anti-avoidance rule was applied to it at all. If you think about what Spotless was about, Spotless was a simple case where the company had $40 million and they decided to put the money in a bank account offshore to derive interest. There is no doubt in the world that the interest derived offshore would not have been subject to tax. No doubt whatsoever. How can it be then that our High Court said that it was? Well, because in order to secure the commercial risks that flowed from the structure, they so structured the commercial deal to ensure that they were not subject to the commercial risks that flowed from securing the tax benefit. It was that the court said indicated that there was artificiality, and therefore, ironically, it was the securing of the commercial parts of the structure that denied them what they could undoubtedly have obtained if they had done it simply and straightforwardly. Now, we've always had a very strong, robust, I shouldn't say always, certainly since 1982, we've had a strong, robust anti-avoidance rule, which we've adopted, and we've now extended that. We've extended that by applying the transfer pricing provisions as part of our anti-avoidance rule. The diverted profits tax is one that sits nestled in, just like a little bird in its nest, in the anti-avoidance rule that we've adopted, where we have made the transfer pricing provisions a part of our anti-avoidance rule. in a way that I'm not sure that theoretically they should be there, but that's a matter of philosophical debate. And of course, we decided the Chevron case where we applied the transfer pricing provisions in a way that seemed to have surprised some part of the planet.
Thank you. Thank you. I know we can carry on this discussion for another equal length of time that we already done. But as we all heard, to say that interpretation of laws, interpretation of treaties will be on the same basis as it was in the pre-BEPS era, in the post-BEPS era, may be absolutely incorrect. There can be different views as to how much will BEPS impact the judiciary outcome, but surely we are going to see some degree of convergence. Will that convergence happen soon? Will it take a period of time before we see maturity in the understanding and applicability of the provisions? That's what time is going to show. What I did take away from Justice Pagone was the length of time that it takes to resolve a matter right up to Supreme Court. And when you say theoretically, it could be in months, I'm sure that's a day which we all in India will also want to have. If not that, the 3 to 5 years is a really great time frame to have in which one can resolve disputes. So with that, thank you so much both for your valued inputs. It was really interesting talking to you, and I hope all of you sitting out there enjoyed the discussions. Thank you.